All right. Well, good afternoon, everyone, and thank you for joining our discussion. I know that with a lot of vaccine and testing announcements that COVID mandates have been on the top of everyone's mind, and in particular for employees nationwide. We appreciate that many of you have submitted questions, and we've looked through them all, and we'll try to address as many of them as we can today. But if you don't hear an answer to something that you need, don't hesitate to submit it through the live Q&A function that we have as part of the Zoom. Remember, this time is really for you. Before we jump in, let me quickly introduce myself. My name is Keith Chapman. I am General Counsel at InstaWork, and as part of my day-to-day, I work very closely with a number of our teams, from product to operations to our trust and safety functions. And we're really working to ensure that InstaWork is helping partners conveniently and reliably fill their staffing needs in what is now a long-term post-COVID world. For those of you who don't know, InstaWork helps connect businesses like you with a growing population of skilled workers that we call professionals. And because our platform scales all the way from the individual up through the industry level, we have a unique perspective on many of the trends that concern you and that you're facing on a day-to-day basis. So we were motivated to start these types of sessions so that everyone in our community has the opportunity to learn from our experiences and from each other. With that introduction, I'm grateful to have Debjani Mishra with me here today. Debjani is a shareholder at Littler Mendelsohn, and she works out of their New York office. She's has both in-house counsel and outside counsel experience, and she's part of Littler's COVID-19 task force and return to work team. One small last administrative note. I know each of us has had our own personal experiences with COVID and any number of the types of responses that we've seen to the pandemic. So while there's a time and a place to debate the merits of any kind of specific regulation around COVID, we want this session really to focus on strategies for compliance with whatever type of regulation we might see. All right, let's start with, I think, a question that has been on everybody's mind this week, and I'll hand it over to Debjani with. We've got OSHA's Emergency and Temporary Standards Act, or their action, and it's generating lots of questions. So what's the current status on the ETS?
So thanks, Keith, for inviting me and for starting with such a small, tiny, discrete question. I appreciate it. And thanks to all of you for joining us this afternoon for this. So just to back up a little bit, because we've all had to learn lots of acronyms and terms that none of us were using 2 years ago. So OSHA is, of course, the Occupational Safety and Health Administration. It regulates workplaces, and generally workplaces that are subject to OSHA, employers who are subject to OSHA have to meet a general duty to keep their workplaces safe from known recognized hazards. So OSHA has been fairly quiet from most employers' perspective until very recently. Not quite 2 weeks ago, OSHA issued an emergency temporary standard. That's the ETS that you hear so much about. Those of you with kids in high school taking standardized tests might have thought of ETS as something else. For this purpose, ETS is OSHA's emergency standard. And adopted this standard on an emergency basis so they can kind of go around the regular rulemaking process and put some things into place quickly for all employers with 100 employees or more. As you might expect, when OSHA acts by emergency, there are people who have opinions about it. So the basic framework of the ETS was to give employers one of two choices. One being have a mandatory vaccine policy that only has exceptions for people who have medical contraindications, reasons why they cannot get the vaccine against COVID-19, or exemptions for those who have sincerely held religious objections to the vaccine. Those two categories could be exempt, but otherwise everybody would be vaccinated. The other choice that employers could take would be to have a policy whereby those who cannot get vaccinated can take a weekly COVID-19 test, and as long as you present a negative COVID-19 test every week, you're clear to work. There's other stuff in the OSHA ETS around safety, masking, quarantining people, giving people time for the vaccine, time for side effects, but that was the main crux of it, to have one or the other one of those things. So the current status of the ETS is that there have been over 30 challenges to it filed, and starting at the beginning of last week and continuing into the weekend, the Fifth Circuit Court of Appeals, which is the circuit that covers Texas, Louisiana, et cetera, had issued an injunction blocking OSHA from having this standard and from going forward with it on a nationwide basis. That challenge from the Fifth Circuit and all the other 30 plus challenges have now been moved over to the Sixth Circuit Court of Appeals, which is based in Ohio and covers a number of states there. And that's the main appellate court that's going to be hearing all of these challenges together. So, where does that leave us right now? Where we were, OSHA was expecting employers to have a policy in place by December 6th, picking which one of these directions it was going to go, either vaccination for everyone except those who can't be vaccinated, or vaccination or testing for everyone. And, depending on which way you went, anybody who needed to be tested would have to start doing that by January 4th. Now that this court challenge is pending, those two dates are on hold. In anticipating some of the questions I know those of you who are familiar with OSHA will have, we don't know how long it's on hold. We don't know what the new dates might be. We don't know when we will know what those new dates might be. And it's hard to predict with any certainty which parts of the ETS will survive. Will it be the whole thing? Will it be part of it? Only some of it? There's a lot that now is left to the litigation process to work out. So that is the current status. We can dig into some more of those details, and I want to make sure everybody knows what we're talking about before we keep talking about it some more.
No, that's a good point. And I guess the one question that I would have, irrespective of what the Sixth Circuit, what the Court of Appeals says, it seems likely that one side or the other will appeal that decision as well. And so it would seem, even if we had some understanding on the timeline, and it looks like it's being expedited, that some or parts of the decision may go up to the Supreme Court for determination, whether on their own action or on appeal, and that will almost certainly slow down the implementation if there is an implementation.
Yeah, I just gave you a list of all the things we're not sure about. I think we're 200% sure that the Sixth Circuit is not going to be the last voice on this. It probably will go to the Supreme Court. And I should say, there can still be more challenges filed in the time, that this is all going on. There can be parties that try to get their case back out of the Sixth Circuit and move it back to somewhere else that they'd rather be. So, there's a lot that can happen. I had someone sort of optimistically ask me yesterday, well, the holidays are coming. Doesn't that mean that, this could take longer? And, I had to think back to my junior associate, new law school graduate days. I think anybody on the phone who's a lawyer, who's spending time with lawyers knows, for whatever reason, lawyers like going into the court on, Friday afternoons, holiday weekends, Thanksgiving Eve. So I don't know that we really recognize holidays. Certainly OSHA, because it's trying to proceed on an emergency basis, they'd like to go forward as quickly as they can. They presumably are prepared to defend their regulation. On the other hand, I think you are going to see a lot of parties trying to slow it down. So that's what makes it hard to predict, what the new dates could be and what they're going to consist of.
Yeah, absolutely. And I think one of the, accepting the fact that we've played a lot of hurry up and now wait, and we're waiting to see what will transpire in the courts, I think that there's still a lot of questions around what best practices might be for, depending on what your standpoint is, for a worst case scenario, for an implementation, for an accelerated implementation. And so I think it may be helpful to kind of, at least at a high level, like walk through the requirements of the ETS. I think you mentioned that, that OSHA regulates, private employers' workplace safety as well. And that, is there a threshold for employer size that is specifically called out?
So for the purpose of this ETS, it's 100 employees. And that's part of the challenge, because there are people saying, well, why is it 100 employees? Is that too small or is that too big? Couldn't there be some employers who have these same issues who are smaller than 100 employees, and isn't OSHA obligated to make those workplaces safe also? And there's probably an argument that because we haven't known up to this point, what specifically does OSHA want employers to do to keep people safe from COVID, assuming that's a responsibility that employers have. So there is an argument that even if you are smaller than that number, or there might be some confusion about whether you hit that number, that some of what's in here reflects, the best thinking we have about how to keep people safe. Things like wearing masks for people who are unvaccinated, or getting sick people out of the workplace. Those are things, those are measures that have been with us sort of the whole time. They're not new as part of this ETS. And there may be a decent argument that even employers that are too small to be covered by this 100 employee cutoff should still be doing those things. There are plenty of businesses all across the US that, only have those numbers. Many of you on the phone probably work with businesses that maybe intermittently just augment a little bit, but aren't necessarily big enough themselves. Those may be workplaces that are covered by OSHA generally, even if they're not covered by this specifically.
So I think that's to that point, like, how do they draw the line? How does OSHA, or what's the guidance around? Is it you have 100 employees in one office? Is it spread out across the country? Is there a look back period? So I think we're seeing a lot of questions around, like, how do we get to that 100 number, either to stay below it or potentially to recognize that a company might be above there?
Sure. So one thing that we did know, because this didn't get enjoined, is that the cutoff date was November 5th. So if you had 100 employees on November 5th, we'll get into how you count that, then you're covered. Even if you then later drop below the 100. The rationale on the 100 was an employer that has at least 100 employees probably has the wherewithal and the resources to do the things that the ETS is thinking about in terms of either mandating vaccines or mounting a testing setup. They weren't trying to impose it on much smaller employers than that. If you didn't have 100 employees on November 5th, but then at some point while this regulation is in effect, you grow to that level, then you would be covered from that point forward. And again, using the old dates that we have, that would have meant that by December 6th, you needed to have a policy, and by January 4th, you would need to start testing employees. We will see whether those dates move around and whether there's any relief. We know this is, the period for seasonal hiring. So you could have situations where companies briefly get over that 100-person limit and then come back down again in January. So this is, one of the issues that's going to be litigated. But the general idea is it's 100 employees measured at the enterprise level, not the location level. So they give the example, OSHA gives the example that you could have, 2 employees each in 50 states. If you've got a really interesting business model, and that would be 100. A lot of things are not spelled out the way they are under some of our other, laws that have been in place a long time. But one of the things that we've, generally advised as a rule of thumb is you don't want to get super creative and vary off of the way that you've counted your employees for other things. If you have ways that you've classified people for payroll purposes, for wage hour purposes, for leave of absence purposes, if you know that, for example, you have more than 50 employees, you hit the FMLA, you should be using consistent methodologies. Because if you try to get too creative about this, OSHA may come in and say, well, we see that you treat these people as all employed by the same employer for this purpose. Why aren't you doing it that way here?
So I guess another question around creativity would be, I know we have a number of partners who may have multiple companies within an umbrella, whether they're subsidiaries or affiliates, but each company would have, say, a specific federal employer identification number. Do we have any guidance around like how far up that kind of corporate chain we would look, or is or could we split out?
Yeah.
Could partners split out, like this company has 40 employees, this company has 60, and they're each separate employers?
Sure. It is tricky, right? And the ETS doesn't give us nearly enough granular guidance. I think, the corporate and tax lawyers would go to town on this stuff if they could, and maybe they are in some of these 34 cases. But you want to look at this from a practical standpoint, because part of what OSHA does is look at who controls the workplace and who's in the building. And so I've certainly had clients who have maybe 3 different payrolls in the same building. You have to sort of imagine that when OSHA comes into a situation like that, if there's been a complaint or if they're auditing or looking for compliance, it may be hard if you have 75 employees on one payroll, 50 on another, and 20 on a third, but they all work in the same building. OSHA is probably going to look at you as being responsible for all of those folks. Having said that, let's say these don't all belong to the same company, right? You've got 75 employees who work for one company, 20 from a staffing agency, 50 from another staffing agency. It might be that no one adds up to 100 employees. You're going to want to very carefully document who is responsible for whom in that building and how this has been arrived at, because that will be what OSHA is looking at. Who took responsibility for these folks? Other things to think about here, just from a practical perspective, we've had employers during the period that people were trying to move towards vaccine tests say, do we need to test staffing agency employees or temps or freelancers or other people who might be in the building? And the short answer is, you may not need to be the person who carries out the test or pays for the test. However, if that staffing agency isn't sending somebody to the building who's going to know who's vaccinated, who's not vaccinated, then you have that practical issue of like, can I let these people work? So somebody at the end of the day in the building has to take responsibility for, being sure that people are working safely. Are they vaccinated? Are they testing? Who's in the group that needs to be testing? And so you're going to want to work out, as part of the arrangement between the different employers, who's taking responsibility for what, and just have that somewhere that you can point to should an OSHA inspector show up and say, who's responsible for what here.
Right. And I think I'd be remiss if I didn't take this opportunity to make clear that for any of the pros that use InstaWork or who are made available through InstaWork, in that pros profile available and viewable by partners, we absolutely, we have incentivized, and we've gotten, I think, more than 50% of our pros have already voluntarily uploaded their vaccine status into their pro profile, and that information is visible to partners. So you can see that when you're making decisions about how you're filling staffing needs. Kind of moving through some of what you said, to the extent we're dealing with companies who use temporary staffing, whether it's through an agency or not, like how does that impact? I mean, how does that impact accounting? It sounded like you were at least alluding to that there may not be a requirement for falling under the ETS, but that from a practical standpoint, you would want to make sure that processes were being followed. But can you just expand on that a little bit?
Sure. So one of the things that people have paid a lot of attention to in the OSHA ETS is creation of a roster, figuring out who is in the building, the roster of the people in the building, and accounting for everyone, collecting everybody's vaccination status. And the issue is, who counts towards your roster? So if you have people who work purely remotely, they might not count. If you have temporary employees who are not on your direct payroll, they're agency staff through someone else, they won't be on your roster. You don't have to include them in that count of 100. You don't have to be responsible for vaccinating them. You don't have to be responsible for their tests. However, on the other side of this, and I say this, multiple times a week and have for the last 2 years almost, COVID doesn't know what anybody's status is. So from the standpoint of enforcing the safety rules in the building, making sure that people are wearing masks if they're supposed to be, making sure that sick individuals or symptomatic individuals get out of the building, and that you do contact tracing. Whoever controls that work environment is going to have to take responsibility for those things as a practical matter, because there won't be someone from whoever the employer of record is to jump in and assist with that. So, similar to how you think about other safety or, interpersonal personnel relations type issues, somebody's got to take responsibility for the day-to-day interaction there and make sure that everybody's covered and that you don't have a source of risk, either to the temps or to the regular staff, to make sure that everybody is just picked up one way or the other.
Kind of moving through some of what you said earlier. So originally the guidelines around the ETS said that there was a date when the companies needed to have a plan in place to either vaccinate or to have a mask protocol. And I think you mentioned that the only individuals who might be exempted from a vaccine mandate would be ones who were able to demonstrate either a medical reason or a sincerely held religious belief reason. Can you expand on what that means and how, for example, employees could request such an exemption?
Sure. So this has been a huge area, and I would say probably one that the administration didn't maybe think would be as difficult as it's been for a lot of employers. So, focusing in on the federal laws, we have Title VII of the Civil Rights Act of 1964, which prevents religious discrimination, requires accommodation for people's sincerely held religious beliefs and practices. Then we also have the Americans with Disabilities Act that protects employees who are otherwise qualified to perform the essential functions of their job, but have some condition or impairment that affects major life activities. The ADA piece of this is a little bit simplified in this case, and that's something I almost never say about the ADA ever. But the basic issue here in terms of medical exemptions is, does this individual have a medical reason why they cannot get the vaccine, either temporary or permanent? Temporary reasons could be things like the person had COVID too recently and is not recommended to get the vaccine yet. The current recommendations are, if someone has recovered from COVID within the past 90 days, they shouldn't get the vaccine during that window of time. But once that window of time passes, they should get the vaccine. From the CDC's perspective and based on the science that we've seen, the combination of recovery immunity and vaccination immunity is far stronger than just recovery immunity. This is something that continues to be studied, but that would be a temporary accommodation. You just got over COVID last week, you can't get the vaccine yet. Another temporary accommodation might be the person's currently undergoing some kind of medical treatment that would interfere with the vaccine or that the vaccine would interfere with. That's a small handful of things, but those things exist. Then there's the category of permanent reasons why someone can't get the vaccine, and those are pretty limited. We're really looking at the healthcare provider saying this person cannot get the vaccine because of a medical reason. That could be allergy to the ingredients, so that the person can't safely get it. There can be certain kinds of immune conditions. Maybe a person is an organ transplant recipient and they take medication on an ongoing basis that is a bad interaction with the vaccine. But it's really a decision for a healthcare provider to weigh in on and to say, this person can't get it. An employee who sort of simply raises concerns or who's been doing their own research or comes forward and says, well, I read on my cousin's Facebook page the following, that's not a medical exemption. That could be a medical concern. That could be something that could be referred to a healthcare provider. You really want the healthcare provider to say this person can't get it. What we've seen more and more recently is healthcare providers saying, not this person can't get it, but I've discussed it with my patient. The patient's chosen not to get it. That is not the same thing. The issue is really, is there a medical reason that the person can't get it? On the religious side, and this is the part that's been taking so much time, it is not well defined what would be a religious objection to the COVID-19 vaccine. There's, a small number of established religions that object to certain kinds of, vaccines or medical interventions, but there really aren't large religious groups that have sort of stepped forward to oppose the vaccine. What we've seen more and more is individuals raising certain kinds of objections to the vaccine, ostensibly on religious grounds. The analysis that you're going to have to go through is this person actually stating a sincerely held religious belief as opposed to a political belief, a general objection to being told what to do, some sort of interpretation of the Constitution or international law or something else? Is this actually a religious belief? And does the religious belief actually conflict with taking the vaccine? That is a difficult analysis that you have to go through. There's not a lot of well-settled law about this, because if you think back prior to this, normally you didn't see very many accommodation requests for religion. They might be very simple things. Can I work Sunday instead of Saturday? Can I, not serve ham? Things that were pretty self-contained, not indefinite requests to be permanently exempted from something. And so it's important for a company to figure out what its approach is going to be to this, because I can tell you in our experience, we're seeing clients get hit with religious exemption requests in numbers unlike anything we've seen before. Dozens, hundreds, even thousands of individuals raising these requests. You can anticipate on the staffing side that you're going to have people who, who have left other jobs because of vaccine mandates, who may be looking to staffing as maybe a short-term way to bridge their employment. They'll be coming to you and raising these requests. You've got to be prepared with a process for reviewing the requests, respectfully, thoughtfully, but also, applying the right legal standards to this to determine, is this really what it appears to be? And would there be a hardship if we were to accommodate it?
Sure. So before we get to hardship, I guess one question would be from a practical standpoint, how should employers think about a scenario where, say, they get a letter from a doctor that says my patient has chosen not to get the vaccine, or they get a accommodation request that arguably does not fall under a religious accommodation? How can an employer kind of address those, like, ostensibly like deficient requests?
Yeah, I mean, if the issue is that the person, has not provided the information that's required, you can absolutely say, we need, on the healthcare side, we need a statement from a healthcare provider. You've raised some medical concerns, but we encourage you to speak to a healthcare provider because your sort of own statement of concern is not going to be sufficient. This is a little bit tricky, and you're going to want to check carefully to make sure that that's consistent with the law of the state that you're in, because one of the things we've seen over the last few weeks as well is a number of states going off in different directions and making some of these standards lighter in terms of what an employee might have to show in order to make a protected objection. But you absolutely can go back and ask for clarification of what exactly is the medical issue. On the religious side, what we're frequently seeing is people raising, saying that it's a religious objection, but raising something that's really not religious, like saying, I'm seeking a religious exemption because I believe that the vaccines haven't been tested for long enough. And that is a subjective statement, but that's not, it's an opinion. It's not really a religious opinion. And so, you can ask follow-up questions. You can, depending on what they've told you, ask about whether they've, received other kinds of vaccines. If someone says, well, I don't consume anything artificial, you can ask whether they've taken other pharmaceuticals. You want to be careful about that. Make sure that your questions are, on the right side of the line with that. But ultimately, an employee is obligated to give you enough information to enable you to evaluate. And if you've gone through that process with them and they haven't stated a proper objection, you can say, we're not able to give you an exemption. Another way to go about it, the way that some employers have chosen to go about it, is to say, maybe we're not going to get into it with the employee about whether this is or isn't a religious objection. But fundamentally, we're not able to accommodate this objection because, either we have so many or because of the nature of what we do, that we can't have people working safely if they're not vaccinated. This, again, is something you want to be pretty specific about, because keep in mind, this has been going on for 2 years. We have many, many people who have been able to work with some combination of masks and social distancing and testing. And anywhere that that's been the case, you can expect an individual to come back and say, well, why can't I do that? That's safe. I've been able to work safely. What makes that not safe enough? And so you're going to have to really get into what's the job? How can it be done safely? What's the specific reason that this person can't be accommodated? And one of the things that will happen here is it's going to vary based on how many people are vaccinated in the part of the country, right? It'll look one way in, Connecticut, where I'm sitting, where above 80% of people have been vaccinated. And so maybe there isn't a really big critical mass of people who could contract and spread the virus. It's going to look very different in Texas, where maybe a lot fewer people proportionately have been vaccinated, and there's more opportunity for employees to transmit the virus among themselves.
Got it. So taking into account that an employee would need to articulate like a valid request for exemption, and accounting for the fact that an employer may not be able to claim some type of hardship that would allow them to prohibit giving an exemption. If an employer does have workers who are not getting the vaccine and or not complying with a max mandate, I'm assuming that employers can take standard kind of disciplinary action, whether it's suspensions without pay or up to and including termination. Are there any prohibitions on those types of responses from employers?
Yeah, I mean, if someone doesn't have a protected reason and they just don't want to get the vaccine, and you've made the decision as a company that you are going to require the vaccine, then absolutely you can take action where people aren't complying with what is a safety rule. In the same way that if they, didn't use the proper protective equipment, or follow the safety procedures that apply to whatever it is they're doing, obviously, this will vary by the industry, but I can imagine light industrial staffing with safety rules and procedures in place that people need to be paying attention to. You definitely can take action. And again, one of the things we don't want to lose sight of here is even without OSHA, OSHA may be on pause. There are a whole bunch of other requirements that may apply to you or the people that you're doing business with. And so there are companies that have been moving ahead with vaccine mandates. And the key to the mandate is if someone doesn't follow the mandate, yeah, you absolutely can take action to either suspend the person or end their relationship with the company. I know it's difficult. We're in an interesting labor environment right now, but it's hard to it's hard to set rules if you're not going to actually follow those rules. So if that's the policy that you've arrived at, whether it's for organizational reasons or for legal reasons or contractual obligations with a partner, then yes, you absolutely can back that up.
And I guess to that point, are there any prohibitions on an employer saying, irrespective of what is being said at the federal level and irrespective of what's being said at the state or local level, is there any prohibition on an employer voluntarily deciding we are going to adopt a 100% vaccination requirement for workers?
Yeah, the main issues.
Yeah.
The main issues are going to come at the state level, right? The upshot of, where OSHA is it would preempt some of these states that have gone off in their own direction to do something else. If OSHA is not upheld, you then kind of have to go state to state and look at things like, what is the current state of Montana law? Montana says you can't discriminate based on vaccination status. States like Utah, Alabama, Tennessee, Iowa have jumped in on this over the last few weeks. Florida's legislature is currently considering something like this. So you may have to look locally to see what's going to happen. Sometimes, like as in the case of Iowa, there might be something that says if you terminate someone for not getting the vaccine, they still get to qualify for unemployment. So there can be little things like that that you have to look for. Whatever you may think about OSHA, the advantage of it is that, that would be one rule that preempts a lot of this state to state variation that different states have come up with.
And are there any kinds of like prohibitions on states like issuing these types of regulations, or any timeline that they would have to do it by, or is it something that is fluid?
Yeah, well, there's actually more than 20 states that can issue their own OSHA regulations. So, there's still the possibility. Certainly California has been kind of out there all along with its Cal OSHA and its regulations, and the brand new as of 2 weeks ago, administrator of federal OSHA actually came from California OSHA. So we imagine that they plan to continue pursuing what they've been doing. Virginia is a state that had been out there with its own plan. Of course, Virginia now has a new governor and a party switch coming in. So, it remains to be seen what they might do. New York has its own legislation, the HERO Act. So there are states that can be more protective as well. And the way that OSHA outlined its ETS was to say, we are going to preempt anything that is less protective. We're not going to touch anything that's more protective. So, some of you will be familiar that in different industries like healthcare, hospitality, that there are requirements around the country that even before OSHA required you to get into vaccination status, maybe require the vaccine for different categories of employees. You also have for federal contractors, the federal contractor requirements for those doing business with the government. In healthcare, many requirements, especially if you participate in Medicare or Medicaid or your contract partners do. So, we are seeing more and more that there are these state and local and some federal requirements, and then also businesses are imposing these requirements on each other.
So if a company has kind of specific questions about where they're located or where they're operating, what resources would you recommend for kind of knowing what obligations they may be facing?
Call me. No, there's a lot out there, but I do recommend, because this changes so fast, honestly, multiple times a week. I do recommend taking a look at state websites, because the governors and the public health agencies have been pretty active about posting where they currently stand. Looking at Department of Health resources in your state and Department of Labor resources in your state. These things tend to be announced somewhere, particularly things like, Iowa changing the unemployment insurance rules. So at least, get a handle on where you might be. We certainly have been maintaining libraries of this. Littler has a COVID-19 resources page. I think we've put out over 16 or 1700 articles at this point in the last couple of years. All that stuff is free and available. Many of our webinars are also available on demand to kind of get you up to speed on this. But this is something that's moving very, very quickly. I know it's top of mind for everybody, not least because here we are still sitting in these Zoom boxes after all this time. So it's hard to ignore that this is still happening.
Yeah, I know you've been getting tired of my unadorned kind of like Tiki Hut look. Shifting gears a little bit, like assuming that folks are going to put some type of either vaccination requirement or mask mandate in place, on the logistical side, like what are some best practices around documentation or protecting information? Like what should people be thinking about?
Sure. So this has been something that we've been talking to employers about for a good 8 months or so, right? Even regardless of whether you think employers should be getting people vaccinated or should have anything to say about it, it's really hard to argue that it's not in your interest to know who's vaccinated, because that guides what safety needs to be applied to them, how they can work, who they can work near, where you might be able to send them, whether they might need to have sick time available or things like that. So, important, if you take nothing else away, HIPAA does not have to do at all with asking employees or staff for their vaccination status. You can ask them for their vaccination status. Even in the most restrictive states, you can still ask employees whether they've been vaccinated or not. And if they decline to answer, you can treat them as though they're not. There are some little variations, like in Montana. One of my partners always says Montana is a fictional place. So we'll set those to the side. But you can collect that information. Under the OSHA ETS, the rule would be that you actually collect vaccine cards or collect proof that someone has been vaccinated. Prior to this, some employers were just collecting statements. An employee just signs a statement saying I was vaccinated. The new rule, if the ETS comes into play, you won't have to go back and re-verify for anybody you already got status from, but you would have to, going forward, actually collect some proof of vaccination. You want to keep that, whether it's a statement or a copy of the card or a note from a healthcare provider, keep it outside the personnel file. You keep it in a separate medical file, or if you have a software solution, keep it in a confidential medical area of the person's electronic file. OSHA has said these should be treated as medical records, and they should be retained for as long as the ETS is in effect. That could be 6 months. Maybe it'll be extended. We will, see how this goes. But you should keep it separately, and you should define carefully the group of people within the company, within the organization, that needs to know for the purposes of enforcing COVID safety. Obviously, people are free to disclose their own status however they want to. If you have an employee who wants to go around telling everybody I'm vaccinated, great, they can do that. But you should not be the one disclosing that information. In California and in Connecticut, there are some special rules about not disclosing people's vaccination status. And so there are some additional forms that you have to fill out. California is always big on forms. But in all the other states, you can simply tell employees when you collect status that information may be disclosed as necessary for business reasons. And that could include situations where perhaps you are sending staff somewhere and the people that are getting them are wanting to know, are you sending me people who have been vaccinated? So you don't have to get consent from the employee, but you do want to give them probably the heads up. We may disclose your vaccination status as needed, which would include customer inquiries. It would include government inquiries and so on.
That makes sense. You mentioned that it should be kept in a location that's separate from an employee folder. What would you say to companies that may not, in a normal course of business, like maintain a personnel file for employees?
Yeah, you will want to find something. There are some third-party solutions out there, whether they're apps or software solutions. To the extent that you have anything that people submit time cards to, very frequently there's a module that's been created just for this purpose, because all those providers understand that every employer now needs to do this. So people who use Workday, SuccessFactors, other HRIS type software for tracking employees in any way at all, whether it's to get their I-9 forms or whether it's to get their pay records, all of those software platforms seem to be adding on additional features to collect this information because it's just needed in so many different contexts now. So I would reach out to, if you use any software at all. If not, you may have to create physical folders for people because you need to have this information in order to make other responsible decisions that flow from there.
That makes sense. It looks like we've got a question coming in just saying, where can we find a copy of the form that California folks would need to use?
Yeah, there's not one form. You will want to talk to, if you're in California and you've done anything around the California Consumer Privacy Act or the Confidentiality of Medical Information Act, those two pieces of legislation are what relate to this. If you haven't done those things, it sounds like you may need a few extra forms additionally. But there's probably not a template that's available just for this purpose. But you can certainly send us a note after, and we can probably hook you up with something.
Okay, so just to kind of put a bow on that, the state specific mandates in California are tied to the state's protection of either consumer privacy or data that would be considered part of that the Consumer Privacy Act, or this California also has its own medical document specific regulation that creates standards by which employers would need to follow and protect certain information, and that this falls somewhere in that universe.
Yeah, if you were doing any of the health screening last year, you would have run into the same problem. Whenever you collect information from an individual in California, there's certain disclosures and notices that you're required to give them. You probably run into it more often as a consumer than you do as an employee, but it's the same requirement that you let people know, we're collecting your vaccine information for a legitimate business reason, and we'll be disclosing it, if we'll be disclosing it, to people according to the following conditions. Is there likely to be a lot of litigation about this? Who can say? It's California. There's always a lot of litigation in California, right, Keith?
That's, it keeps us busy.
It's your natural, I think it's your greatest resource.
that and sun and wildfires, I think. The top
wildfires and sometimes floods.
Yep, sometimes. So one more follow-up on that would be, particularly in California, we have requirements to make sure that we can make an employee's personnel files available to them. Are there any kind of comparable or parallel requirements on vaccine status or other type of COVID-related documentation that we need, like that, where record keeping and making those records available would come into play?
Yeah, so there's actually some requirements under the OSHA rule. If the stay gets lifted, there are some requirements about making data available, making people's own vaccination information available back to them, and also making aggregate information available not only to OSHA, but to employee representatives who may ask for this information. So you have to have a way of providing kind of de-identified aggregate information about, the percentage of the workforce that's vaccinated. So there are a few things that are like that are part of the OSHA ETS as well. And then as a practical matter, there may just be this issue with your contract partners. If you're sending people somewhere, they may be asking, who are you sending?
Yeah. Okay. Because vaccines are a effective way of helping respond to COVID, but they're not the only one that's prescribed. I think there are a lot of questions that we're seeing coming up around testing, about like what cadence is required. And I think maybe most importantly, how should employers think about making time available for testing, and most importantly, paying for testing?
Yep. So I'm going to put a big disclaimer on this, which is you definitely are going to want to talk to whoever advises you about wage hour issues on this one, because this is one where there's huge variation in how different states approach it. There may be variation in how you approach it within your organization. And obviously, any one of you who's ever been involved in a wage hour litigation knows you don't want to go to one. I avoid them as much as I possibly can. I don't even like to talk about them. There's a few different potential sources for the test cost, just the cost of taking the test, to be the employer's problem. From the OSHA perspective, OSHA doesn't create any new rule in terms of requiring employers to pay for tests. They've said quite clearly they prefer that people get vaccinated, and so they're not going to burden employers with the cost of testing for people who opt out of vaccination. But they can't override every state law that exists on this from a wage hour perspective. There are a number of states where there are medical testing laws that are in effect. And the question is, how will those laws be applied to this? Because those laws mostly relate to situations where you're doing pre-employment testing. Some of them apply to situations where you're doing kind of fitness for duty, testing. But for the most part, there's about 30 or so states that have some kind of law on the books that somebody could argue makes it the employer's responsibility to pay for a regular test. However, each of those are written differently. They look at what the source of the requirement is differently. So you're going to want to actually dig in and look at your state's law and any guidance that's been issued. We're starting to see states issuing guidance that is specific to this as a result of the OSHA ETS being out there. The other thing that you can have is business expense reimbursement. Again, California is big on this. If an expense can be said to be job related, there is the possibility that you may be on the hook to reimburse the employee for that. And then you have the category of accommodation that, if somebody, let's say, medically can't get the test, in order to provide a reasonable accommodation, you may be, as the employer, on the hook for that cost of that test on an ongoing basis. So, those are different ways that the test cost could become the responsibility of the employer. The other issue here is time, and that's also going to be all over the map, pun intended, because there are different rules in different states about the time it takes to do certain things, whether these things are done at the work site or somewhere else, whether travel time to and from a pharmacy to take a test is going to be compensable. And so, it's going to matter very much how you set up this policy. The wording is important. Is it mandatory? Is it a choice? Is it the employee's choice? Is it the employer's requirement? Is it at the work site? Is it somewhere else? So this is really complicated. We probably haven't gotten any question more than we've gotten, can you just send us a chart? I wish that I could just send you a chart. There are some things that defy the power of even Microsoft Excel. But this is one where you're really going to want to think about what is it that we're trying to do? How are we going to do it? The other thing I would say from a practical standpoint, Keith mentioned I was in-house. You all know, anytime you have something that you just leave it up to employees to figure out on their own, you're going to have shenanigans. There are going to be people who show up and say, oh, I didn't get the test. I forgot. It wasn't there. It was a line. I was running late, traffic, something. And so if you have an expectation that people are going to do something every day every week on a certain day, and they're going to get it done in a certain way, you're going to have to look at how can we make that happen? And for employees who maybe, we're talking $600 a month in test costs, that may be something that an employee is not in a position to front and be reimbursed for. It may just be something that doesn't happen. So from a practical standpoint, as you're thinking about, do we go mandate on the vaccine? Do we allow testing? This is all stuff you have to factor into that. Again, knowing the pandemic is still happening, we still have cases, we still have deaths, unfortunately, every day. How do we have our people working safely?
On that point and on kind of the cadence of testing, are there, assuming that the ETS is implemented at some point, are there any requirements around frequency of testing? Is it daily?
Yeah.
Is it weekly? Is it something else?
Yeah, it's at least weekly. An employer can decide that they like it so much they're going to do it more. And if you have people who are working remotely, you don't have to test them when they're remote. You might be able to just test them before they come into work in person somewhere. But for people who are regularly working in person, it's weekly.
Weekly. And for folks coming in remote, I'm assuming that the recency of whatever test that they would provide, that would also probably have to be within a week.
Yeah. So it would be, a test every week, and you have to actually get a result every week. And of course, that's going to raise issues too for those of you who have to deal with any kind of predictive scheduling or paying for reporting time. If people report to work and then they're tested at the work site and sent home. So yeah, my wage hour specialist colleagues will be very busy for the rest of time.
Well, I want to be cognizant that we're coming up on the hour. So before we kind of get into kind of closing remarks, one thing I wanted to make clear for everyone who's listening is what InstaWork is doing and how we can also prepare for the future. So I think, as I mentioned earlier, we make and incentivize pros to upload their vaccine status to make sure that we have that information. As it becomes more and more required, that it's readily available and can, if we need to, we can provide it to our partners. I think one of the other things that we're making clear and that every partner can do right now is when they're posting shifts, they can very clearly articulate what their specific requirements are, whether it's state mandated, federally mandated, or company mandated requirements. We can put that information into each shift so that workers know, at the outset, what they may be required to do or what processes they'll have to follow. We also have, since the beginning of COVID, have been working to make sure that we have facilitated contact tracing. So if there is an infection or if someone tests positive within a work environment, we can have that information and distribute it in accordance with our safety procedures, and that we, as needed, have had workers that can sign basically health attestations before coming onto a shift. And some partners, may still want to require that, irrespective of what they're doing with masks and or vaccines. So at the end of the day, we're doing everything that we can think to make it safe and to get the appropriate and necessary information out to our partners. And we're always open to hearing back from them on what types of steps they'd like to see, or how we can make this process easier on them. But I think at the end of the day, one of the questions that we're looking at is, because we're in such an uncertain time, because laws are evolving so quickly, are there any kind of last high level takeaways for how folks should think about preparing for the future?
Yeah, I think the big thing right now is honestly making choices. And I talk to a lot of employers about choices week to week, really setting, okay, what are our objectives and what are the things we need to do in support of that? And what will the consequences be? For a lot of the folks on the phone, this indefinite remote work that some of us are living in, that's not the reality for employees. And so, what are the things that need to be done so that work can continue to be done as safely as possible? If we don't require the vaccine, what's that going to call for in terms of testing? Are we going to need to provide sick pay to people when they're sick? Because people will continue to get sick. Are there, organizational cultural reasons that we want to be known for doing one thing or another here? Are there demands of the marketplace that we need to pay attention to? But, everyone's got to come to their own decision on this. And I think I would just say, there's this feeling sometimes, especially for those of us who live in the boxes, that, this thing is mostly over. It's definitely not over. That's not reality for everybody. So, given that we're at this inflection point, starting to get cold again, cases are starting to tick up again, how do we make responsible choices and set the tone and not, just maybe simply be waiting for the Sixth Circuit or any other circuit to tell us what we're going to do?
That's great. All right, well, Devjani, thank you as always so much for your time. We certainly appreciate it, and for all this guidance. I'd also like to thank everyone for attending. And I recognize that we did have some questions come in, but if this has sparked anything, or if you have questions that pop up later, please feel free to email us. You can contact us directly at hello@instawork.com, and our team will route those questions to the right people, and we'll try to get the best, most current information back to you. So to everyone, thank you again, and we appreciate it.
Thanks, everyone.